So I think we're going to get started. Thanks everyone for coming to the first of the workshop breakouts in this conference. My name is Cynthia Wong. For those of you who don't know me, I'm with the Center for Democracy and Technology. I actually have a number of colleagues in the room also that I will introduce in a moment. But I just wanted to give a few just framing remarks about the objectives of this workshop and what we hope to get out of it, and then we will proceed from there. So we kind of put this together based on some of the research that we're doing and some of the trends that we're seeing in the work that we do around intermediary gatekeeping, intermediary liability, and its impact on free expression. And just to give just initial level setting, and I know this is probably review for a lot of people, but one of the things that we have seen that's changed because of the internet is that traditionally governments have been the primary duty bearers for protecting human rights. They're the ones who are primarily responsible for protecting human rights. But as we all know today, so many of the tools that we use to communicate with each other, to access information, to find jobs, to do many other things in our lives, really depend on tools that are actually operated and owned by private parties, right? So by companies, by non-state actors. And so that, I think, represents a big shift, and that shift is really important for a couple of reasons. Primarily, governments are beginning to view these intermediaries, these companies that provide our social network or search engine, as efficient ways to enforce local laws. And when governments ask companies to play the role of policeman or play the role of gatekeeper for the information that we can access online, for the things that we can say online, we think it raises really clear issues of rule of law, of due process, and it raises really clear issues about accountability for when human rights are harmed, when governments go to these intermediaries. And so for that reason, we thought that one good use for this workshop, well, I guess three goals for the workshop really. The workshop really is an effort hopefully to provide space to examine specific case studies of how governments are turning to intermediaries and turning them into policemen for the internet. Discuss lessons learned from advocacy campaigns that have been conducted around those specific case studies. And then finally, looking forward, have a real nuts and bolts discussion about what additional work needs to be done to counter some of these, what we view as threats to free expression, and some of these problematic developments, and really talk about in a nuts and bolts way what additional resources, what research, et cetera, would be useful to counter some of these trends. And I will say that at least from CDT's perspective, we view legal protections for these intermediaries from liability for bad things that users do online. We actually think that's just as important as Article 19, the right to free expression, as the First Amendment in the US, for protecting free speech in the internet age, because so many of the platforms that we use are actually owned by these private companies. So I'm actually going to stop talking, and I'm going to actually, so let me, I guess, go over the workshop format. First, I'm actually going to turn to two other just initial speakers to kind of give a frame on this issue that is not coming from the US. We are a US-based group, and I think this is an issue that's going beyond merely the US. So I'm going to introduce those speakers, and then we're going to go immediately into breakout sessions where we have 5 facilitators that are going to focus on 5 different case studies that they've worked on personally, and they will lead the breakouts depending on what the interest is in the group. And then we're going to come back together and talk about some of the lessons learned, some of the ideas for advocacy and ideas for how to take this work forward afterwards. So does that sound good to people? Not that we have a choice. But okay, so first I'm going to turn to 2 distinguished speakers just to give 5 minutes on kind of what their view is on 2 questions. First, what they see as the biggest threats to freedom of expression when it comes to intermediary liability and turning companies into policemen for the internet. And second, what are some of the best opportunities they see in their work for countering some of those threats? So first I'm going to actually ask Eduardo Bertoni from CELE, and if you want to say something about what your center does, then that'd be great too.
Okay, well, thank you, and thank you Cynthia and CDT for asking me to make this some sort of introductory remarks. I'm Eduardo Bertoni. I'm currently the director of the Center for Studies in Freedom of Expression and Access to Information at Palermo University School of Law. Our School of Law is based not in Palermo, Italy, but in Palermo neighborhood, a beautiful neighborhood in Buenos Aires, Argentina. And I always make the same joke, so This is that joke. We launched early this year one program strictly related to internet. We call ELE, in Spanish is Iniciativa por Libertad de Expresión en Internet, which is Initiative for Freedom of Expression in the Internet. And we do research on different topics in partnership with some organizations like the Derechos Digitales from Chile. Our colleagues are here, and other CDT helped us in one of the research, so this is what we are doing. Trying to answer Cynthia's question, as in our experience, there are 4 or maybe 5. The 5th one is something that I put at the end, but maybe it will be good to be discussed in one of the groups. Maybe it's already included in one of the groups. But we found four issues related to intermediary liability, freedom of expression, and I would say content suppression or content control in the internet. First issue is defamatory content. We found cases, for example, in Argentina. It's a very well known, the cases about the celebrities that initiated a process against Yahoo or Google because of the search engine activities that led people who Google their names to some websites that are websites that they don't want to be mentioned. These are more than 100 injunctions in Argentina, and there are cases at the first instance courses that adjudicated responsibility to intermediaries because of the damages that these third-party actors, who are the ones who put the photos, for example, in the website, are doing. So the intermediary, in this case, search engines, are liable for doing search their own activity. So defamatory content is first. Second problem in our view, Latin America, very big problem, copyright. We had cases, for example, in Colombia. Carolina Botero is here. She can say much more and better than me about the problem in Colombia and how there are new legislation that include some provisions to control piracy, but affect freedom of expression online. We need to talk and to discuss TLC agreements in this area as well. Okay, so this is second, or free trade agreements, I would say, in this area. Second problem. Third problem is related to hate speech or discriminatory speech. We found in some circumstances that having, the good faith and having in mind good goals, policymakers try to introduce some obligations to intermediaries or give some official institutions the possibility, for example, to detect content that is hate speech content. And when they say detect, they are not explaining what that means. And detect could be, for example, control content of the oral communication with technological methods like DVI, for example. So this is the third problem. And the fourth one is child pornography, which is, again, we agree it's important to combat child pornography, but in some circumstances, there are some ideas or some movements that try to push intermediaries to policy, to monitor in some way the content of communications to combat child pornography, and this could be a very big threat for the privacy of the communications and free speech. The fifth one that frankly we are not following, we are not saying problems right now, but could be a problem, is all of related of cybersecurity and search in the internet, and some possibility of the government that want to give again the intermediaries the possibility to police the communication under the framework of anti-terrorism laws, for example. This is something that we need to be aware of. We didn't detect problems yet, but maybe there are. So it would be good for this group to raise those. That's all for me, and the big opportunities. The big opportunity is that in Latin America, particularly, there are fragmented regulations about those things. There are not many regulations, and some people start thinking in regulations. So we have the big opportunity to help in drafting good regulations in those areas for not affecting. Okay, should I start again? I love that. So no, we have a very good opportunity in my region, in Latin America, to help in drafting good regulations. Well, I finish with that.
The first is, it's not really clear that intermediaries will go out of their way to protect free speech, especially when it doesn't undermine their bottom line. We conducted what we call a policy sting operation. We identified 7 of the largest intermediaries, both national and international, that operate within India, and we sent them fraudulent takedown notices. We would use provisions available in the law, but we would complain about legitimate content. And we found that in most cases, these intermediaries overcomplied. If we complained about 3 comments at the bottom of a news item, they would delete all 13. If we complained about 3 URLs that showed up in search engine results, they would clean the search engine index of all 3,000 URLs from that particular website. So we started to push it, take it to a more and more ridiculous level. Finally, we complained that an e-commerce website selling nappies was harmful to minors because nappies cause diaper rash. And that was the only occasion when the intermediary resisted and pushed back, because on that occasion, it undermined their bottom line. So while intermediaries might travel the world and act as if they are great champions for free speech, in reality, they save their best lawyers for acquiring patent portfolios and for mergers and acquisitions. And the people looking at takedown notices, to my mind, appear to be interns from law schools. So we can't trust intermediaries. And even if we have a perfectly well-designed regime, we will have to keep watching them to see what it is that they do. So that is the threat. I can't say that we have enough evidence to say that this is the case, but this is what it looks like. The opportunity is the confusion over jurisdiction creates what I would call free speech havens. Google and 20 other intermediaries were taken to the magistrate courts in New Delhi for hate speech in 2 different cases, a criminal case and a civil case, by a Hindu and a Muslim petitioner, just to keep things even in a so-called multi-religious state. But Google India was let off, and so was Yahoo India, perhaps. So one other intermediary had an Indian entity as part of the complaint. Facebook. And the argument made was that Facebook India only provided technical services to Facebook based in the US, and therefore could not be considered liable for the content hosted on Facebook servers. And a similar argument was made in the case of Google. It gets even more exciting when those intermediaries don't even have offices in India. So arrest warrants can't be issued against persons who are within the Indian territory. This is a huge opportunity. The lack of harmonization of policy across jurisdictions is a huge opportunity for civil society, and it allows us to push the boundary as far as free speech is concerned within our countries. Thank you, Cynthia.